Hey there, estate planning attorney Paul Rabalais here. And in this video, we're going to talk about big problems that can occur when spouses have different heirs and the solutions to those problems. All right, so many times couples who engage in estate planning, they've got the same heirs. The typical, we've only been married once, we have 2 children of our marriage, and after we both pass away, we both want everything to go to our 2 children equally. Simple enough. But in many cases, spouses have different heirs. Let me give an example. And I like to use some kind of fictional characters in some of my examples. And you may remember the old, if you're about my age, you may remember the old kind of afternoon comedy show called The Flintstones. And the couple in The Flintstones the main couple was Fred and Wilma. So let's say Fred and Wilma have a child together. That was Pebbles. But let's also say that Fred had a child from a prior relationship or a marriage. And maybe it was determined that Fred had Schleprock from a prior marriage. So this problem starts to surface, and I see it early on. So to make the couple understand the problem, I ask them a question like, you know, this probably isn't going to happen, but this helps us get to where we want to get. So let's say, for example, you both die at the same time, Fred and Wilma. Where would you each want your respective share of the estates to go? That takes out the fact that they're trying to leave things for each other, and it eliminates that and really gets to the point, you both happen to pass away in the same time. Probably not going to happen, but if that happens, where would you want your respective estates to go? And let's say they had an estate that they equally owned that was $2 million. So if they both passed away, you know, Fred's part would be $1 million and Wilma's part would be $1 million. If you both died at the same time, where would you want that to go? Well, Wilma's is likely to say, I have a child, Pebbles. I'd like my share to go to Pebbles if we both die at the same time. Whereas Fred is likely to say, well, if, you know, I certainly want to take care of my wife first, but to answer your question, if we both die at the same time, I would want my share to go to Schleprock and Pebbles, 50-50. So now we got a potential problem. And so what Fred and Wilma did, though, was, you know, they said, Fred woke up one day, realized he didn't have a will, and he said, you know what, Wilma, let's go get a simple will. And so whatever that means. And so Fred says, you know, I love my wife, Wilma. I'm just going to leave my estate to Wilma. I love my wife. All of what we have, we built it together. I want to leave my estate to Wilma. And Wilma says the same thing. And Fred's thinking as part of his simple will, he says, I want to take my simple will one step further because I have Schleprock. So he leaves his estate to Wilma in his will. But he also says, if Wilma happens to die before me, then when I die, I want my estate to go 50-50, Schleprock and Pebbles. So he thinks he's got Schleprock covered. Okay, so what happens? They get that simple will done, and a few years later, Fred dies. And they look at Fred's will. Fred's will, he died before Wilma, so he left everything to Wilma. So his $1 million went to Wilma. Now Wilma has the entire $2 million. And then when Wilma dies later, guess who's going to get Wilma's estate? Wilma's estate was left entirely to Pebbles. Bad luck, Schleprock, out of it, you know, doesn't get a penny because Fred left his to Wilma, Wilma left hers to Pebbles, Schleprock gets 0. And guess what? As many times as I've been asked this question by the Schleprocks of the world, the bad luck Schleprocks, as he was called in the Flintstones, you know, Schleprock comes to me under those circumstances and says, you know, Mr. Rabalais, but that's not fair that my dad left everything to my stepmom and then my stepmom left everything to my half-brother. That's not fair. And so Schleprock might even try to make that argument to a judge. And never in my life have I seen the that's not fair argument work in circumstances like that. And it probably never will work because the judge, when it gets to that, is going to say, I'm going to interpret the law and the facts. My job isn't to determine what might have been fair or unfair. Fred had a will. Judge is going to say, Fred had a will. He chose to have a will and leave his estate to Wilma. And then when Wilma died, her will leaves her estate to Pebbles. Sorry, Schleprock, bad luck, Schleprock, case closed, get out of my courtroom. So that's what would happen. Now, there are a couple of things that Fred could have done to both provide for Wilma and protect the future inheritance rights of not only Pebbles, but Schleprock as well. Fred could have left his estate. Remember, they had $2 million. Fred's portion is $1 million. Wilma's portion is $1 million. Fred could have arranged his estate so that when he died, his $1 million went into a trust for Wilma because he wanted to provide for Wilma. And he may have provided for Wilma through a trust that probably said something like, if that trust produces any income, it goes to Wilma. Could have even said Wilma would be entitled to distributions of the principal of that trust for her health, education, maintenance, and support, the very common HEMS standard, HEMS. And when Fred sets up that trust in his will, Fred's selection of who will be the trustee of that trust is very important. Fred may say, when I die, I want Wilma to be the trustee, and I want to allow her to take distributions from the trust pursuant to the HEMS standard, her health, education, maintenance, and support. Or Fred might say, I really don't want to give Wilma that much power. I'm going to name Barney Rubble, as the trustee of that trust so that when I die, Barney can be this kind of independent third party that can assess Wilma's needs, and Barney can make the determination of when distributions would be necessary for Wilma's needs. So that trustee selection under those circumstances is very important. And by leaving things to a trust, when Fred leaves things in a trust for Wilma for the rest of her lifetime, Fred is able to provide what happens to those trust assets when Wilma later dies. And Fred's going to say, when Wilma later dies, those remaining trust assets will revert back to Schleprock and Pebbles 50-50. Wilma has no say-so as to where those trust assets go when Wilma dies. Wilma has say-so as to where her $1 million of assets goes, but she doesn't have any say-so as to where Fred's $1 million of assets go when Wilma dies. Fred left it to a trust for Wilma to revert back to Schleprock and Pebbles when Wilma later dies. I hope you're following all that because it's really important. That's one thing that Fred could have done. The second thing that he could have done, particularly if most of his money was in a traditional IRA, is he could have named Schleprock as a beneficiary of a portion, as a primary beneficiary of a portion of Fred's IRA. Now, Fred, you might be thinking, Fred could name a trust as the beneficiary of his IRA, similar like the situation before. Wilma gets the income. Wilma can use principal if she needs it, but when Wilma dies, all of the trust principal reverts back to Schleprock and Pebbles. But the thing you got to be real careful about when you name a beneficiary, name a trust as a beneficiary of a traditional IRA to provide for your spouse and have those assets revert back to your beneficiaries when your spouse dies, is because we have all of these required minimum distribution rules, also referred to as RMD rules. If after Fred dies, he left his IRA to a trust for Wilma and then comes back to Schleprock and Pebbles when Wilma dies, but if Wilma lives long enough after Fred dies, the required minimum distribution rules are going to require that all of that IRA that's in that trust be distributed to Wilma. So when Wilma dies many years later, there's no assets left in that trust to revert back to Schleprock and Pebbles. So bad luck, Schleprock is out in the cold again. So be careful when you name a trust for a spouse and then your heirs as the principal beneficiaries of that trust. It may not work out well if that surviving spouse lives long enough and has to take all the distributions out of the trust pursuant to the RMD rules. Okay, so that second option is naming Schleprock or a trust exclusively for Schleprock as a primary beneficiary, along with Wilma as a primary beneficiary. Maybe Fred would say, I'm going to leave 70% of my traditional IRA to Wilma, I'm going to leave 30% of my IRA to Schleprock or to a trust for Schleprock if Schleprock's young. Schleprock is a mouthful. Okay, so estate lawyers often refer to these circumstances or these situations as blended families. You really have to be careful, and you really have to understand how trusts can be used in circumstances like this, where married people want to provide for their spouse, but they also want to protect the future inheritance rights of their heirs or beneficiaries. So be aware, big problem out there, see it all the time. People don't address it right. They come to me after the fact and I'm like, sorry, nothing I can do. The problem was the planning wasn't done right, and now that they died, too late. Sorry. So don't be one of those. Be one of those who watches videos like this, likes, subscribes to channels like this so you don't miss anything and you get notified as I keep producing this estate planning educational content. So, you've worked so hard for what you have. Take a little bit of time and effort. Make sure we get this right. We'll see you next time.